The hearing will come to order. Thank you all of the commissioners for being with us here today as the subcommittee conducts an oversight of the Federal Trade Commission. The Commission has a broad mandate to protect consumers from unfair and deceptive trade practices. Its consumer protection mission includes protecting consumers from everything from robocalls, ticket bots, and data breaches, and enforcing laws such as the Consumer Review Fairness Act, the Fair Credit Reporting Act, and the Children's Online Privacy Protection Act. This is the first opportunity for this subcommittee to hear from all 5 new commissioners since their confirmation this past spring and learn about their enforcement priorities. This spring, the Commission announced it would hold a series of hearings titled Competition and Consumer Protection in the 21st Century, with the goal of exploring whether evolving business practices and emerging technologies might necessitate changes to the FTC enforcement policy and priorities. So far, the Commission has held 7 hearings on topics which included big data and artificial intelligence, with data security and privacy hearings to be held in the next few months. I would like to hear from the commissioners about the response they have gotten to the hearings, what they have learned so far, and what, if any, policy or enforcement guidance might result. I'm also interested in what the Commission can share on its investigation into Equifax and Facebook. In September 2017, the FTC announced that it had opened an investigation into Equifax's massive data breach that affected the personal information of at least 148 million Americans. The breach apparently went unnoticed by Equifax for more than 70 days, and once the company finally realized that a breach had occurred, the company waited 6 weeks to report it. The breach put consumers at high risk of identity theft. Last March, following the Cambridge Analytica scandal, the FTC also confirmed that it was investigating whether Facebook's privacy practices violated the Commission's 2012 consent decree. This subcommittee held a hearing on June the 19th focused on how the use of the app by about 300,000 Facebook users ultimately resulted in the personal information of nearly 87 million Facebook users being transferred to Cambridge Analytica. It would be useful to know if the Commission has an anticipated timeline for when the results of that investigation will be announced and what penalties the company might face if the Commission determines its practices did violate the consent decree. Privacy has emerged as an area of major concern for consumers. In the past month alone, Facebook and Google revealed the exposure of personal information of up to 30 million and 500,000 users, respectively. And these are just the latest in a long series of incidents that have raised serious concerns about privacy practices of large tech companies and the adequacy of their responses. In the wake of these incidents, the implementation of the General Data Protection Regulation, GDPR, in Europe, and the recent passage of the California Consumer Privacy Act, it has become clear that the U.S. needs a federal consumer data privacy law. My colleagues on the committee and I are pursuing a bipartisan privacy legislative proposal. As the primary federal privacy regulator that has brought over 100 data security and privacy cases over the last 20 years and issued privacy guidance, the FTC has a unique experience and expertise to call on when we work to develop that privacy legislation. I look forward to hearing from the commissioners about what they think should be included in any federal privacy legislation and what additional tools the FTC might need in order to continue to effectively protect consumer privacy while still encouraging and enhancing innovation. With that, I turn to the ranking member so that he can make his opening statement.
Thanks, Senator Moran. Thank you to you and Chairman Thune for your leadership. And I have been working with Senator Moran on a bipartisan privacy bill that I hope will make very good progress very soon. Congress has long empowered and directed the Federal Trade Commission to enforce the tools it has now, not to mention new ones that we may give it in such a privacy law. And looking back, this year really exemplifies the urgent need for the FTC to be more vigorous and vigilant in its enforcement, to stand up for consumers, promote competitive markets, and combat fraud. And I will be very blunt. First, thank you all for your service, but thank you for recognizing, as I hope you will, that all too often the FTC has fallen short of that enforcement trust. It has fallen short on confronting pressing challenges. Sometimes it's because the Commission lacks the needed tools, but too regularly the problem appears to be lack of will. And I say that with great respect, based not only on my 8 years as a United States Senator, but 20 years as a law enforcer at the state level, Attorney General of Connecticut. This hearing is about finding out whether the FTC is ready and willing to take on hard problems and whether the FTC will robustly protect privacy using the authorities and resources that you have now and that we will hopefully provide. We've seen the consequences of lack of enforcement with Facebook. After over a year of foot-dragging on Russian interference, earlier this year we learned a political firm had secretly amassed Facebook data on tens of millions of people to manipulate our election. Cambridge Analytica should never have happened. It would never have happened if the consent order reached by the FTC with Facebook had been vigorously and adequately enforced. When Mark Zuckerberg came before the Senate, I showed him the terms of service of Cambridge Analytica's app. He acknowledged that Facebook was not paying attention and promised change. In fact, he said he hadn't seen him before. Instead, we have learned that while Mr. Zuckerberg embarked on this apology tour, surrogates of Facebook were maligning critics and members of Congress. That issue is only one of many, and it won't be the last, I'm afraid. My colleagues and I have raised countless more concerns about Facebook's privacy and security practices. I have been frustrated that there has been no cost to Facebook for catastrophic failure to protect consumers. And I will be asking, like Senator Moran, where the investigation stands and when we will see results. Facebook has captured the headlines, but it's hardly alone. In July, the Wall Street Journal disclosed that Google had potentially exposed the private data of hundreds of thousands of Google's users. Google's instinct was concealment. A memo from Google policy staff, quoted by the Journal, warned disclosure would likely result in, quote, us coming into the spotlight alongside or even instead of Facebook, despite having stayed under the radar throughout the Cambridge Analytica scandal, end quote. I, along with Senators Markey and Udall, wrote the FTC about this incident, and I hope for a response today. This issue is about big tech, and Congress is fed up. It's about big tech no longer being entitled to say to America, trust us. Big tech is no longer entitled to that trust, if it ever was. And big tech maybe is no longer entitled to be as big as it is. Misuse of bigness can be in violation of antitrust laws. There may be nothing that prohibits the amassment of market power, but misuse of that power can violate antitrust laws. And so it's not only privacy, consumer protection, but also antitrust that has to be assessed. You all know, America is well aware that we all carry with us the most sophisticated tracking devices ever invented. Our phones monitor our movements on a minute-by-minute basis. They are privy to the most intimate conversations. We use them as credit cards and to monitor our health. They may know us better than we know ourselves. And the ones collecting the data yielded by those phones know us the best of all. That is also big tech. And worse, there is little that any individual can do about it. That's not the basis of innovation. It's an invitation to disaster. We have seen this year that the misuse and abuse of our data represents a threat to consumer safety, but also national security, the defense of our nation, and the health of our democracy. We need changes. I look forward to collaborating with my colleagues on this committee to pass bipartisan legislation that sets clear rules of the road on consumer privacy and other issues essential to our national security. And we need to do it not only because Europe has done it, not only because California has done it, but these rules are long overdue. We can't simply endorse the status quo. And these real changes must include, at a minimum, rules passed by Congress that will provide all Americans with the same or better rights and redress than California and Europe. Move us beyond the failed notice and choice regime and set requirements for transparency, access, and control. End the secret harvesting and sale of personal data through requiring reasonable data minimization. Provide the FTC with the resources and expertise and structure to enforce the rules. Establish meaningful penalties on first offenses to pose a credible deterrence, and recognize the importance of state attorneys general to ensure that violations are investigated and punished. And finally, to end where I began, any rules that we pass need to be enforced. That FTC consent decree, already on the books, should have prevented Cambridge Analytica. The FTC simply can't claim to be surprised here. If we let Facebook and Google police themselves, set their own goalposts, make their own rules, they will always come up short. And so I look forward to hearing whether the FTC is up to this task, and we need a commitment from you to end the cycle of impunity. Thank you, Mr. Chairman.
Thank you, Senator Blumenthal. Senator Nelson, would you care to make an opening statement?
Thank you, Mr. Chairman. The FTC, the premier consumer protection agency, set up in 1914, it's the bedrock of American consumer protection. The agency is tasked with policing and promoting competitive markets and with protecting consumers from unfair or deceptive acts or practices. And despite the important mission and enormous mandate, the FTC remains a relatively small agency. For years, I have consistently advocated that the FTC be provided with more resources so that you can effectively do your job, particularly during an age when the American economy is becoming increasingly complex and digitized. And with a little over 1,000 full-time employees, the FTC can only do so much in a $19 trillion economy. It's my hope that Congress will finally do the right thing by providing the FTC with the increased funding and personnel to police the marketplace and to protect American consumers from a myriad of scams, frauds, corporate practices that fleece them from their hard-earned money. It is my hope that the FTC continues to operate in a bipartisan and a consensus manner. It is all too common today, not only from this institution, but from the administrative agencies, that we are beginning to see creep into the agencies the same thing that is happening in the body politic, the tribalism that is now entered and dominating our political milieu. The Commission has a long, proud history of bipartisanships. It's a tradition from which other independent agencies should draw. Too often, agencies like the FCC or the CPSC, Consumer Product Safety Commission, they get mired in competing individual ideological agendas. And we speak in this committee from a position of knowing, because we have the oversight of both the FCC and the CPSC. And by and large, the FTC has avoided this kind of dysfunction, and it served the American consumer well. Congress obviously can learn from your example of bipartisan deliberation and cooperation. And to the FTC commissioners before us in the committee today, thank you for your public service. It's been a privilege and an honor to have worked closely with you during the tenure in my capacity as ranking member on this committee. Thank you again, Mr. Chairman.
Thank you, Senator Nelson. We're now ready for that testimony. We have before us today Federal Trade Commission Chairman Joseph Simons, Commissioner Rohit Chopra, Commissioner Noah Phillips, Commissioner Rebecca Kelly Slaughter, and Commissioner Christine Wilson. It is my understanding that your testimony is going to be a joint testimony and will be delivered by the chairman. Mr. Chairman, you are recognized.
Chairman Moran, Ranking Member Blumenthal, and members of the subcommittee. It is an honor to appear before you today, especially alongside my esteemed colleagues. As Senator Nelson said, the FTC is a highly productive and efficient independent agency with a broad dual mission to protect consumers and to maintain competition. The FTC has a long history of bipartisanship, and we work hard to maintain it, and we will continue to work hard to maintain it. I'm going to focus my oral remarks today on data security and privacy. Year after year, these issues top the list of the FTC's consumer protection priorities. The Commission has challenged numerous privacy and data security practices under Section 5 of the FTC Act. Our program in these areas, which includes enforcement as well as consumer and business education, has been highly successful within the limits of our authority. But as mentioned, Section 5 is an imperfect tool. In my view, we need more authority. I support data security legislation that would give us three things. One, the ability to seek civil penalties to effectively deter unlawful conduct. Two, jurisdiction over nonprofits and common carriers. And three, the authority to issue implementing rules under the Administrative Procedure Act. The Commission also urges the Congress to consider enacting privacy legislation that would be enforced by the FTC. While we remain committed to vigorously enforcing existing privacy-related statutes, we are hopeful that Congress can craft legislation that would more seamlessly balance consumers' legitimate concerns regarding collection, use, and sharing of their data, while providing the flexibility to foster competition and innovation to the benefit of consumers. This process, understandably, will involve difficult value judgments and trade-offs that are appropriately left to the Congress. No matter the specific privacy or data security laws that Congress enacts, the Commission commits to using its extensive experience and expertise to enforce them vigorously and enthusiastically. Irrespective of any new legislation, privacy and data security will continue to be a top enforcement priority for us, and we will use every tool in our existing arsenal to redress consumer harm to the extent we can on our existing authority. To date, the Commission has brought more than 60 cases alleging that companies failed to reasonably protect their consumer data, as well as more than 60 general privacy cases. Since I became chairman, we've announced 8 new enforcement actions, 7 policy initiatives, a notice of proposed rulemaking to give active military consumers free credit monitoring, and the launch of our small business cyber education campaign. We have no intention of slowing down. The FTC also enforces the Privacy Shield framework, a mechanism that enables data to be legally transferred from Europe to the United States. Our commitment to support the Privacy Shield framework is unwavering, and we will continue to enforce and uphold it. Let me mention one additional item. The FTC has a tradition of self-critical examination, and our public hearings on competition and consumer protection in the 21st century are exploring whether we need to adjust our enforcement efforts, our priorities, and our policies in light of changes in the marketplace and new thinking. Issues we are discussing include whether we need to change the governing standard for antitrust enforcement, whether merger enforcement has been too lax, our remedial authority, whether privacy and data security, and many other critical issues. The comments and discussions on these issues will inform the FTC's enforcement and policy priorities. We are committed to maximizing our resources to enhance our effectiveness in protecting consumers and promoting competition, to anticipate and to respond to changes in the marketplace, and to meet current and future challenges. We look forward to working with the subcommittee and the Congress, and I would be happy to answer your questions. Thank you.
It's my understanding that my understanding was incorrect, that you all hoped to make an opening statement. We do not have your written testimony as required by our rules, but I think it would be a mistake for us not to hear from you if you're prepared to do so. So we do not have in front of us their written statement, but all the commissioners would like to make a statement. And I now recognize Mr. Chopra.
Okay. Chairman Moran, Ranking Member Blumenthal, and members of the subcommittee, thank you for holding this hearing. The FTC has a clear mission to make sure markets are fair and competitive, not corrupted by conflicts of interest, distortions, and lies. The primary way we seek to accomplish this is through our law enforcement program. Today, I want to talk about some of the most important questions that the FTC must routinely answer when enforcing the law. Given all the misconduct in the market, which companies are the best targets? And after investigation, when should we push for a settlement, and when should we go to trial? In my view, no matter how big or powerful they might be, we must hold companies accountable for widespread failures, and we must always be willing to take them to court. 45 years ago, Congress gave the FTC the authority to sue companies and individuals in federal court using Section 13B of the FTC Act. The FTC can go to court to seek restitution for victims, take back harmful practices, and seek other changes to business practices. And like almost every other federal enforcement agency with the power to take companies to court, the FTC resolves most of its actions through settlements. And without question, settlements are important. No agency can litigate everything, but no agency should ever appear to strong-arm small defendants into financial ruin while letting large companies off the hook with a slap on the wrist. Now, in the aftermath of the financial crisis, we saw how large firms saw settlements as nothing more than the cost of doing business. After all, corporate boards on Wall Street almost never agreed to a settlement that threatened their profit model. And while big penalties made for good headlines, I question whether they truly deterred lawbreaking. Too many individual executives evaded accountability and even got rewarded with a bonus for their skillful dealings with the government. Unsurprisingly, even after big settlements, we saw how agencies continue to fight fire after fire with companies like Wells Fargo, where abuse was widespread. In trials, we get to find out the whole story, told from both sides, by the actual individuals who called the shots. And we see due process in action. And when the government prevails, the law can provide for recoupment of certain taxpayer costs. Now, the FTC has shown it is willing to go to trial. Too often, pharmaceutical companies go to great lengths to protect monopolies created by their patents. Take the example of AbbVie, the pharmaceutical giant famous for continuing to raise prices and creating billions of dollars in healthcare costs with the blockbuster drug Humira. In 2014, the FTC sued AbbVie for filing sham patent infringement lawsuits that stopped generic drug makers from challenging another top-selling product, Androgel. A few months ago, A court ruled that AbbVie did indeed use sham lawsuits to illegally maintain its monopoly. The court ordered the company to pay up $448 million for its wrongdoing that harmed patients, the public, and its competitors. After the ruling, we saw pharmacies who were allegedly harmed by these practices filing their own actions, and certain aspects of this matter remain on appeal. In another matter, after years of litigation and a trial, a court ordered Dish Network to pay $280 million for its do not call violations. And in a few weeks, the FTC will begin its trial against semiconductor giant Qualcomm for its alleged anti-competitive tactics in the chip market. Filing a lawsuit and taking a powerful corporation to trial is tough. In my past agency experience, I've seen how going up against a company with legions of lawyers and lobbyists and PR professionals can be daunting for an agency with finite resources. But Congress cannot expect any agency, including the FTC, to meet its mission unless it is unambiguous to the market that we have the resources and the resolve to go to court, no matter how big or connected a company may be. It will be critical for Congress to continue to support our 13B authority and to ensure that every law enforcement agency exercises its prosecutorial discretion in ways that create real accountability for those that break the law. Thank you, and I look forward to your questions.
Thank you, Commissioner. Commissioner Phillips.
Thank you. Chairman Moran, Ranking Member Blumenthal, distinguished members of the subcommittee, thank you for the opportunity to appear before you today. Thanks especially for Senator Nelson for his thoughtful and kind remarks earlier. I'm honored to be back here, especially with my fellow commissioners, to highlight the important work that the FTC and its talented staff do every day on behalf of American consumers. In my brief remarks, I'd like to address two international issues, as well as the legislative process that you all have undertaken on consumer privacy. While offering incredible opportunities for American consumers, the digital economy poses new challenges for law enforcement, particularly relating to cross-border activities. In 2006, Congress recognized this and passed the U.S. Safe Web Act, allowing the FTC to share evidence with and assist foreign authorities in matters involving issues such as privacy violations and data breach. U.S. Safe Web also confirms our authority to challenge foreign frauds that harm U.S. consumers or involve material conduct in the United States. Using Safe Web, we have worked with foreign authorities to stop illegal conduct and secure millions for consumers, and sometimes even obtain criminal convictions with the help of our partners. Safe Web is a vital tool, but it sunsets next year. Congress should reauthorize it and should eliminate the sunset provision. Next, the FTC works with the Department of Commerce to enable transatlantic data flows and support American business leadership through 3 cross-border data transfer programs, including the EU-US Privacy Shield. We, as an agency, look for Privacy Shield violations in 4 ways. First, referrals from the Department of Commerce. Second, priority referrals from the European Union. Third, we look for violations in every privacy investigation that we conduct as an agency. And finally, we conduct proactive monitoring of Privacy Shield participants. We are committed to the success of these cross-border data transfer mechanisms. We have brought nearly 50 actions over the course of their lives, and enforcement will remain a priority for all of us. Finally, on the ongoing debate we are all having as a nation on consumer privacy, I want to stress 3 points. First, privacy can be a nebulous concept. And as you consider legislation, it is critical to be clear and frank about the wrongs you seek to right. Advocates for new regulation invoke a variety of alleged market failures to justify new rules, from data insecurity to imperfect information about data sharing to creepiness and surveillance. According to the NTIA, while online privacy concerns appear generally to be declining, Americans' level of concern about privacy issues varies based on the subject, with people substantially more concerned about issues like identity theft and consumer fraud than, for example, the collection of data by firms or the loss of control of data. Reasonable minds can differ on the privacy risks, but everyone should agree that the best policy is developed when aimed at clearly defined harms and with consensus built about how to address them. High-profile incidents and large firms dominate headlines, but legal restrictions have an impact that is broader and more fundamental. Second, any new rules will come with trade-offs to consumers, innovation, and competition. As I've said elsewhere, regulations can chill innovation and competition, including by entrenching incumbents. We need to keep small businesses and startups in mind. To be clear, that is not to say that we should not reevaluate our privacy regime, given emerging issues and technologies. But neither can we ignore half a century of our nation's experience balancing privacy and other interests, including tremendous levels of innovation. On innovation, America has been leading. I am concerned that early indications about the European GDPR indicate reduced investment in technology and greater concentration in ad tech. The trade-offs are not easy, and there are no simple answers. So my third point is that, given the important value judgments that must be made, Congress is the place to make them. Broad delegations to an expert agency are a poor substitute for the lawmaking process that our founders created. I was honored to work here in the Senate for 7 years, so I have great faith in the capacity of Congress to listen to the public, to build consensus, and to reach the right answer. Of course, the FTC, with our talented staff and half a century of experience enforcing privacy law, stand ready to assist you in fashioning legislation, and we will enforce any new privacy authority that Congress deems fit to assign us. Thank you for your time, and I look forward to answering any questions that you may have.
Thank you, Commissioner. Commissioner Slaughter.
Thank you. Can you hear me? Yes. Chairman Moran, Ranking Member Blumenthal, and members of the subcommittee, thank you so much for inviting us here today. I've spent my first 6 months at the FTC immersed in getting to know the talented staff of the agency and understanding the opportunities and challenges they see on the ground as the Commission fulfills its dual missions of protecting consumers and promoting competition. As Senator Blumenthal noted, in today's increasingly data-driven and concentrated economy, consumers demand and deserve vigorous enforcement from the FTC. That is precisely what Chairman Simons has pledged, and I join him in his commitment. We should and we will enforce the law against wrongdoers to the fullest extent that our authority and our resources allow. And we should continue to engage in critical self-examination to identify ways we can do more within those parameters. However, I want to use my time today to highlight how additional resources and authority would enable the Commission to better protect consumers and promote competition. Let me first address resources. I'll begin with an example. In 2012, the FTC sued a payday lender known as AMG that buried consumers with illegal fees. The FTC aggressively litigated this matter and ultimately secured a hard-fought $1.3 billion court order against the defendants in 2016. 2 months ago, in late September, the FTC returned over $500 million to AMG-related victims. The outcome in AMG is instructive in 2 ways. First, it demonstrates that the FTC provides meaningful results for consumers that far exceed our resources. On that one day in September, we returned to consumers more than our entire appropriated budget for fiscal year 2018, which is about $300 million. In fact, during all of fiscal year 2018, Commission actions resulted in over $1.6 billion being returned to consumers, more than 5 times our annual budget. Put another way, the FTC provides an extremely good return on investment for the American taxpayer. The AMG resolution also demonstrates a second plain but paramount point. Good outcomes for consumers take time and money, especially where the target of the investigation is a large, well-financed corporation. There is simply no substitute for careful, thorough investigation and, where appropriate, aggressive litigation. I agree with Commissioner Chopra's comments about the value of litigation, and I want to be clear about what it means from a resource perspective. Litigation requires teams of dedicated and talented staff and complementary resources. Cases such as AMG and the AbbVie case that Commissioner Chopra mentioned demonstrate the talent and the dedication are here. But imagine how much more we could be doing with additional resources. The challenges consumers face in the marketplace today are growing in number and complexity. To address them, the FTC must initiate more investigations and litigate more cases. Those cases have become more complex both legally and technologically, and they involve defendants with deep pockets and armies of attorneys. Our resources have not kept pace with these developments. As one key metric, consider that we had about 50% more full-time equivalent employees in the beginning of the Reagan administration than we do today. It is critical that the FTC have sufficient resources to support its work, particularly as demands for enforcement in so many complex areas continue to grow. In addition to sufficient resources, sufficient authority is critical for the FTC to meet the demands of the 21st century marketplace. Expanding our authority to seek monetary penalties for violations of the law, providing the FTC with better rulemaking authority, and eliminating jurisdictional exemptions would each go a long way to help the FTC better meet today's challenges as well as tomorrow's. I want to highlight in particular that the limitations on our authority are particularly constraining when it comes to protecting consumer data. No matter how big the breach or how egregious the conduct, the FTC has no authority to seek financial penalties for most types of abuse or misuse of consumer data. We also lack the authority to engage in notice and comment rulemaking in the areas of consumer privacy and data security. And the common carrier and nonprofit exemptions put some of the largest hosts of consumer data beyond our reach. I strongly support Chairman Simons's call for Congress to consider enacting federal privacy legislation that would address these limitations. I believe we need a law that requires companies to take consumer privacy seriously, gives the FTC the authority to impose significant penalties for failing to do so, and invest the necessary resources for the FTC to carry out Congress's directive effectively. I look forward to continuing this important dialogue with you and to taking your questions.
Thank you. Now, Commissioner Wilson.
Thank you, Chairman Moran, Ranking Member Blumenthal, and distinguished members of the subcommittee for the opportunity to appear before you and testify today. It is an honor to be here for the first time since I joined the Commission 2 months ago. I would like to highlight today one of the areas I identified as a priority during the confirmation process, the healthcare industry. As you know, this industry impacts every American and takes a bite out of each paycheck. Given its importance, it should come as no surprise that the FTC is quite active in this segment of the economy. I would like to briefly discuss 2 issues associated with healthcare, one related to consumer protection and the other to competition. On the consumer protection side, the marketing of unproven or ineffective treatments for serious health conditions is unfortunately all too common and rightly remains a top priority for FTC enforcement. One important area is marketing that targets opioid addiction. The CDC estimates that a staggering 115 Americans die every day, from an opioid overdose. People seeking life-saving help for opioid addiction or withdrawal must get the right kind of help as soon as they are ready to receive it. Products that promise miracle cures or fast results can cost precious time and money and can contribute to relapse or even death. The Commission has sued 2 companies that marketed bogus withdrawal and addiction treatment products. The FTC also is conducting a number of non-public investigations in this area. Thanks to the leadership of members of this committee, including Senators Cortez Masto and Capito, the FTC can now bring civil penalty authority to bear when companies market sham opioid treatments and services. And earlier this year, the FTC partnered with the FDA to send warning letters to marketers selling products that claimed to help with opioid addiction. The FTC also collaborated with the Substance Abuse and Mental Health Services Administration to release a fact sheet on getting the right help with opioid dependence or withdrawal. Armed with our expanded resources, the FTC will continue to support local, state, and federal agencies combating the opioid epidemic. On the competition side, the FTC has long recognized and challenged false and unsubstantiated health claims, but REMS abuses, in contrast, are a relatively recent problem. The FTC continues to investigate allegations that branded pharmaceutical companies misuse risk evaluation and mitigation strategies, known as REMS, to impede competition. In theory, a REMS program is designed to protect patient safety by managing the known or potential risks associated with the use or distribution of certain medications. Oftentimes, that is also the practice. But sometimes, branded manufacturers misuse REMS to thwart entry by would-be generic competitors. This conduct upsets the careful balance between competition and innovation that Congress established in both the Hatch-Waxman Act and the Biologics Price Competition and Innovation Act. REMS abuses can take various forms, but regardless of the precise method employed, concerns arise when branded manufacturers subvert laws and regulations that are designed to protect the health and safety of consumers and instead use those frameworks to insulate themselves from competition. By excluding competitors from the market, branded drug companies can price products higher than they otherwise would, preventing drug prices from falling. Recognizing that REMS abuse is a competition problem, the FTC has used its existing powers to investigate potential antitrust violations and is actively looking for a good case to bring. The Commission has also engaged in advocacy, including filing amicus briefs in private litigation. We are grateful that members of the subcommittee share our concerns and have proposed legislation that would more directly address this problem. FTC staff have provided technical assistance on various bills, and we will continue to support these important legislative efforts. I am happy to answer any questions you may have.
Thank you very much. I'm going to defer to the ranking member who has another hearing to attend. I'll turn to him for questions, then it'll be my turn, and we'll work our way across the dais.
Before he leaves, I want to join in thanking Senator Nelson for his leadership over such a distinguished and extraordinary period of time. Thank you, Senator, for I also want to thank each of you for your testimony today, and I want to begin with coming back to big tech. This morning, a member of the UK Parliament disclosed that an entity with Russian IP addresses was pulling over 3 billion data points a day about Facebook users using fraudulent means. This allegation is new and chilling. Mr. Chairman, were you aware of it?
Not until it was reported.
Facebook never disclosed it to you, and they never disclosed it to us, correct?
That's my understanding.
I am assuming that the FTC continues to have an ongoing investigation, correct?
Yes, absolutely.
It has been 8 months since the FTC first indicated that investigation. Since then, the United Kingdom's Information Commissioner's Office issued penalties to Facebook regarding the matter of privacy violation. And on Sunday, a UK parliamentary committee also seized a trove of documents from the company 643 regarding Facebook's privacy practices. The urgency of this investigation could not be clearer. Can you tell us when you will be done and when you will have results of this investigation?
Thank you, Senator. So it's inappropriate for me to comment on a specific non-public investigation, but let me say the following. So anytime you see a press report of a significant privacy issue, a potential privacy violation of our authority, it is safe to assume that we either are investigating it already or shortly after that media release, we will investigate it. The other thing to keep in mind is when companies have problems that become public that are serial in nature, new, as you described, new problems, you can also assume that we will be looking at those too.
Well, I'm not here, with all due respect, Mr. Chairman, and I do have great respect for you. You're saying it's safe to assume. It is not safe to assume anything.
It is safe to assume what my staff is doing, what our staff is doing.
But we need to know, and that was my question, when you will have some results, because these continuing violations clearly show that we have something more than a single bad actor problem, and it is not only Facebook. I want to be fair to Facebook. It is not only Facebook. And one of the most dramatic and important questions that was asked, and I asked it during the hearings with Mark Zuckerberg, was how many more Cambridge Analyticas are there out there? We still have no idea. So I think you have an obligation to tell us when you think this investigation will be done.
We're going to do this. Our goal is to do this as fast as possible and get to the right result as soon as possible. But I cannot comment on the details of any specific non-public investigation. I'm
How
sorry, Senator.
many full-time employees are assigned to investigate Facebook's privacy and data protection practices?
Again, I can't comment on a non-public investigation.
Are you satisfied there are sufficient resources devoted to this investigation? That
is my goal with respect to every investigation that the FTC is conducting, and especially the most important ones.
Facebook knew about Cambridge Analytica at least since December of 2015. Did Facebook disclose this matter to the FTC prior to March of 2018?
Again, Senator, I'm sorry, but it's inappropriate for me to comment on the specific details of a non-public investigation.
Well, without being unduly critical of your predecessors, are you satisfied that the Facebook consent decree was adequately enforced?
What I would say is this. We do engage in self-critical examination. It's a very important part of our history, and we take that very seriously. And so one of the things we are looking at is how to modify our orders to make sure that things that shouldn't have happened before don't happen again.
Are you monitoring the Cambridge Analytica bankruptcy?
Again, I don't want to comment on a specific non-public investigation.
Do you have any investigation concerning the issues relating to Google that I mentioned earlier?
Again, I can't comment on any non-public investigations that may or may not be going on.
Well, I think that, again, with all due respect, the American people really deserve to know more about these ongoing investigations, either generally as to time frame, amounts of resources, and indeed whether you have wrongdoing and abuses under investigation. I'm not talking only about Facebook, but about other companies as well.
Our goal is to vigorously enforce, and we are working hard at that, and I think we are going to, one thing I hope to do, Senator, is I hope to turn your opinion around in terms of the performance of the FTC. That is one of my main goals for you, with respect to you and others in the Congress.
Well, I appreciate that, and I have great respect for, again, the commissioners and the very dedicated professionals that you have working for you at the FTC, and I share my colleagues' view that to some extent it may be a matter of resources, but we need to know what is needed for, as you put it, turning around performance. Mr. Chairman, I have many more questions. I'm going to defer to my colleagues now and stay roughly within the 5-minute rule. Thank you.
You were late, you talked long, and our agreement is that you're not coming back.
I will be back. I shall return. But I thank you for those kind words, Mr. Chairman.
Senator Blumenthal has focused on Facebook and current investigations. I just would add to what he said that this subcommittee and me personally will do everything we can to provide you the resources, both legal and financial, and we will continue to monitor. We obviously want more information than you're capable of giving us, Mr. Chairman, at this point in time, but we're going to pay a lot of attention to this issue, and by that I think we're conveying its importance to us, to you. Let me start with the resource question. Senator Udall and I used to serve together on FSGG that funds the FTC. He abandoned me, so I think I'm the only appropriator in the room. I would say to you that I have a strong interest in ensuring that your agency has the resources it needs to effectively and efficiently protect consumers from unfair and deceptive practices. In part, our efforts will be determined by what the administration and you request in your budget submission. I would start with, because I think your workload is growing and I think it is going to continue to grow. I think it's conceivable that Congress will give you greater authorities, but let's start with just what you have current authority to do at the FTC. Let me see if I can get you to tell me in short order, in few words, does the FTC have the necessary resources to enforce its current consumer data privacy and security authorities as provided by Section 5 of the FTC Act and other relevant statutes?
Senator, I think we do, but let me also say that if we had additional resources, I guarantee they could be put to very good use.
So, I mean, I think anyone could say that, Mr. Chairman. I think I've heard that in my own household.
Fair.
So, what is it that you would do if you had more resources? Let me make certain I stick with the current. What would you do under your current authorization? What you're legally obligated to do, what more would you do if you had additional resources?
So I think we would, we have an enormous litigation level going on inside the commission. And if that remains the same, our staff is literally almost killing themselves. They're working so hard on these litigations. If that remains at a historic high level or increases, we would need more resources. We would need more resources for that. In addition, we probably could use some resources with respect to the Bureau of Economics and also technology resources.
It's my understanding that a significant amount of work at the FTC is provided by consultants and by outside counsel. Is that the best method by which you can perform your responsibilities? So
not so much outside counsel, but consultants, experts, so economists, technology people. And what we want to do is we want to have a good mix, because we want to have the technology available to us that we need. And so that may vary from case to case. And so sometimes you'll have new types of cases that you haven't had before, and you bring in a consultant specifically for that case, because that may be, may come and go. It may not be sustained. So I think you want a mix. You want a core of people who are inside the agency and supplement that with outside consultants.
Let me, I've tried to focus, and I want to make sure that any commissioner who has a comment to make about this topic has that opportunity, but I've tried to get you to tell me about current responsibilities and current needs for resources based upon those current responsibilities. I also would ask you that as we develop, and I indicated in my opening statement, and Senator Blumenthal confirmed in his, that we're working to author legislation related to privacy. I also need from you not only as Commissioner Phillips indicated, a willingness to provide us, and a number of you indicated the things that you would suggest in that legislation, but I also need to understand what the additional resources that would be necessary, that would come with additional responsibilities or greater authorities at the FTC. So I want to make sure that as we develop legislation, we're not operating in a vacuum in which we would have the likelihood of saying, well, this is what the law should be, but knowing that the law would be somewhat irrelevant if the resources aren't there to enforce the new authority. So I need to know what additional resources it would take as we develop this legislation. Let me see if any of the commissioners have anything they'd like to respond to my questions or comments that perhaps different than the chairman.
Well, Senator, I'll just add that with respect to data privacy and security, more and more sectors of our economy, whether it's the automotive industry, the agriculture industry, retail, there is more and more data collection, and our largest firms in the economy are relying heavily on how to monetize that data. So this is not just about consumer-facing businesses. It is a bigger and bigger part of U.S. GDP. And if that is going to grow, then the FTC's resources have to grow commensurately. When cities grow and get much bigger, they hire more cops, and we have to do the same for us.
Anyone need or want or need to add something to this?
Yeah,
Commissioner Slaughter.
I'll echo what Commissioner Chopra said and say I agree with everything Chairman Simon said he would do with more resources. I would depart only that I think we do need them. I don't think that we have enough resources right now to do the job that consumers and Congress expects of us. I think we want to do that job. And those additional technologists, those additional employees, getting us anywhere back to near the staffing levels we had in the Reagan administration, I think would be very valuable to carry out our mission.
Let me say, just from my perspective, I've never met an agency or a department or a commission that didn't believe they needed more resources. I hear it on an ongoing basis, but I think this is different. I'm sympathetic to that plea because the volume, as Commissioner Chopra says, the city is growing. And there has to be a greater focus on how we spend the money, but that is insufficient in this case, I think, to have the necessary resources to meet the demand.
Senator,
yes, Senator Phillips.
One very short thing to add, and I suspect my colleagues will agree with me. As my colleagues have said, it bears repeating. We work very nimbly and we work very efficiently. So you should trust in the fact that we are giving great credence to the resources we are giving and we are employing them efficiently.
Thank you. Senator Klobuchar.
Thank you very much, Mr. Chairman. Thanks for having this popular hearing. When you were talking about the town growing, the other thing that has really grown, as the commissioner has known, is mergers. And we've had a 50% increase in the number of mergers in just the last 5 years. And I thank you, Mr. Chairman, for your testimony in front of the Antitrust Subcommittee that Chairman Lee and I have chaired for a long period of time. And as you know, I have a bill to add more resources to that piece of your work by charging some extra fees on some of the mega mergers, the very large mergers. And could you just explain to my Commerce Committee friends here your feelings on doing something like that?
Yeah, so this is one of the things I mentioned before. We have like a historic level of litigation going on at the agency right now, and particularly on the competition side. So when I showed up on May 1st at the agency, there were 4 merger cases being litigated at once. I don't remember that ever happening.
But just to the legislation, because I have so many other questions.
And one of the things we want to do, and which also is, I think, in your legislation, which is to do merger retrospectives. So one of the things we would need to do for that is more economists. So that will help us get a better sense of, whether our merger enforcement has been too lax, whether we have to tighten it up, and how much.
And just for my colleagues' sake, and Senator Lee, Senator Moran is interested in this bill, some version of this, only because it's not more taxpayer money. It is these humongous billion, trillion-dollar mergers that these guys are trying to analyze. And so that's why we are looking at it as a way to get them the resources to do it, as well as the Justice Department with Mr. Delrahim. Secondly, my colleague, Senator Blumenthal, asked a lot about Facebook. As you know, I've been very involved in that with the Honest Ads Act, with the privacy legislation that I have with Senator Kennedy. And could you tell me, Chairman, will the FTC make a statement at the conclusion of this investigation to inform the public of the circumstances surrounding this breach and whether Facebook's action or lack thereof violated the terms of its consent order?
I would think so.
Okay, thank you. Commissioner Slaughter, you were talking, I know you do a lot on privacy. Can you talk about why it's important to have disclosures and on online ads and disclaimers? Of course, this is something that is under some of the FEC's jurisdiction, but in general, why do you think that's important?
Thank you, Senator, for the question. Disclosures help consumers understand what is happening with their data, with the information that they're seeing. The FTC has the opportunity to police against deceptive disclosures in various circumstances. But if there is no disclosure, we could not call the disclosure deceptive specifically in most circumstances. Right. So I think I am familiar with your bill. I think it's a really important contribution to the debate around making sure consumers understand what they're seeing and from whom they're seeing it.
And as you know, some of the companies, including Twitter and Facebook, have done this voluntarily, but we're going to have a patchwork. We have a lot of other platforms that aren't doing it at all, and a complete crazy situation where TV, radio, and newspaper is required, and these guys aren't. Commissioner Chopra, why is it important for the FTC to have enforcement over privacy violations? And could you talk about, we have in our bill, Senator Kennedy and I, notification of consumers of a privacy violation within 70 hours. Do you support something like that?
Yeah, I think we need some clear rules of the road at the federal level of when people's data is essentially stolen from them. Look, you can pass all the privacy laws you want, but if there's no enforcement and no penalties for violating them, no one's going to follow them.
Right. Okay. And then, Commissioner Slaughter, back to you. The CREATES Act, this is something that Senator Grassley and Leahy and Lee and I have introduced on the Senate side. This is, of course, about prescription drugs and trying to get more competition going. Do you believe the legislation could help put a stop to some of the anti-competitive practices? As you know, we're also, Senator Grassley and I have our pay for delay bill that I know we will pass if we could just get a vote. And I know the FTC, all of you have been involved in this issue. Do you want to comment further on that?
Sure. These are very important issues for consumers. Commissioner Wilson in her opening talked about REMS abuse and the problems of REMS abuse, and we're actively looking for opportunities to enforce, but I know the legislation that's out there would make it a lot harder for the bad practices to happen to begin with and a lot easier for us to enforce against them.
Very good. Well, I will ask the Commissioner Phillips and Wilson, I will be asking you something in writing because I have to, my time is now ended. Look at those crossed arms. It is time for me to end my question. So thank you very much for your time and your really good work and your commitment to making the FTC as bipartisan it has been for so long and working together, even though you probably don't agree on every single thing. Thank you.
Pleased to recognize Chairman Thune.
Well, good afternoon, and I want to thank Chairman Moran and Ranking Member Blumenthal for holding this hearing and for their continued work on FTC oversight, and also want to thank all the commissioners for being here today to provide the committee with an update of some of the FTC's activities. Earlier this fall, the FTC began a series of innovation hearings aimed at ensuring the Commission can meet the challenges posed by modern economic and consumer trends. And I'm looking forward to hearing more about how these sessions will inform the Commission's competition and consumer protection work. I'm also eager to discuss possible comprehensive data privacy legislation with the Commissioners as well. Currently, the committee and several key members are exploring privacy legislation, I'm sure as you know, and it would be helpful to know from the Commissioners if you all support this effort, if you think the FTC is an appropriate enforcement agency and what kind of penalties and statutory tools are going to be needed to ensure compliance. Let me start with you, Mr. Simons. Mr. Chairman, in the past, the Commission has used its authority under Section 6B of the FTC Act to study particular industries or practices. For example, in 2014, the Commission completed a 6B study of the data broker industry and issued a report of its findings along with some recommendations. Would the Commission consider using its 6B authority to study consumer information data flows, specifically sending requests to Google, Facebook, Amazon, and others in the tech industry to learn what information they collect from consumers and how that information is used, shared, and sold?
Sorry. 6B is a really powerful tool, and that's the type of thing that might very well make sense for us to use it for.
Okay. Well, I just, it seems to me, at least based on what we know and what we observe happening around us today, there would be a lot of interest among consumers in this country in having that sort of information available. So,
and that may be guided also by what comes out of our hearings.
Right.
And Senator, the 6B studies can actually inform not just our consumer protection enforcement, but in the case you mentioned, also our antitrust enforcement, where data and data flows is of intense interest to us.
Yeah. And I want to shift to that for just a minute because, as I mentioned earlier, this committee has been exploring comprehensive consumer privacy legislations, and we've held 2 hearings this fall, earlier, one with industry and one with public interest groups to discuss the issue of consumer privacy. And this would be for any of you to respond to, but do you support efforts by Congress to develop comprehensive privacy legislation?
Absolutely.
Yes.
Yes, I support those efforts.
Okay.
Yep.
Okay.
Yes.
Good answer. So now for the harder question, and that is, in your view, are there key features that should be included in any privacy legislation?
So one of the things that we've asked for on the data security side is civil penalty authority in order to create effective deterrence. And my sense is that the same dynamic is going to apply on the privacy side as well. So I think that'll be very important, that there's civil penalty authority.
Yeah. Is that a view that's shared by members of the commission?
Senator, I have a slightly different view on that.
Okay.
And it's not a totally settled one. As I said in my opening remarks, one of the things about privacy is that it is a nebulous concept, and different people see different risks as greater. Those are very reasonable debates. A lot of people have strong feelings about this. It is critical that Congress decide what the harms are and then target tools to address those harms. I don't think that the liability standard, what harms we are addressing, can be separated from the civil penalties. You have to think about the two together, what you're enforcing and how. Because what you don't want to do, penalties can chill conduct. You want to make sure that the conduct that you're chilling is bad conduct, not conduct that potentially benefits consumers.
So if I could also address this, first of all, I do encourage Congress to pursue privacy legislation. Businesses need clarity and certainty regarding the rules of the road. Markets work best when consumers have complete information and can make informed choices. And studies show that right now consumers do not understand what is being done with their data. And current legislation does provide protections, but it's been outstripped by technological developments. So, for example, HIPAA protects medical information stored in the doctor's files, but not the medical information collected by your Fitbit. And so I think I perhaps have a slightly different perspective than Commissioner Phillips. I do believe the FTC should be the one to enforce any new legislation that is prepared. And I think in terms of elements of new legislation, I think it should grant jurisdiction to the FTC over nonprofits and common carriers. I think it should provide for civil monetary penalties. I think it should grant targeted APA rulemaking authority. And I think it should be undertaken in conjunction with a national data breach notification and data security law.
Okay, so does everybody on the commission share the view that the FTC is the appropriate enforcement agency for comprehensive privacy legislation?
Yes.
Okay. Yes.
Yeah. Okay.
Yes.
Right.
Yes.
And this, you answered this question too, but to the other members of the commission, should Congress repeal the common carrier exemption to the FTC Act?
Yes.
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 You bet.
Okay. Mr. Chairman, my time has expired, so thank you, and I will yield back.
I would treat you better than I treated Senator Blumenthal. Senator Markey.
Thank you, Mr. Chairman. We're celebrating the 20th anniversary of the Child Online Privacy Protection Act, which I authored back 20 years ago. Now we're seeing where the holes might exist in the modern era. Google's YouTube is a particularly troubling example. Last year, an enormous 80% of 6 through 12-year-olds used YouTube on a daily basis, yet Google claims that even its third most viewed YouTube channel, Toy Reviews for Kids, is not targeted to children, meaning COPPA does not apply. Chairman Simon, in your opinion, is Toy Reviews for Kids targeted to children?
Thank you, Senator. I don't want to comment on any specific investigation that may or may not be going on, but that clearly would be of concern to us, Senator.
I hope it would be a concern because they're collecting data from kids about what their preferences would be, which they can be used to market back to them. I also sent the Commission a letter after a recent study found that thousands of apps were accessing children's sensitive information, such as location, without obtaining the required consent. The study also found that Google's App Store is including games that aren't COPPA compliant in its kids section. Chairman Simons, in light of this evidence, will you commit to investigating allegations that app developers track kids' each and every movement, and whether app stores such as Google take adequate steps to ensure apps labeled as kid-friendly are in fact kid-friendly and do not track children.
We got your letter, and we share your concerns. The Commission has a long history of protecting children from deception and unfair advertising practices online, and this will continue to be a priority for us.
Okay, just for the record, new research found that over half of reviewed apps were violating COPPA, and many games were collecting kids' geolocation data without consent. I urge you to follow up and to proceed accordingly. Earlier this month, I sent the Federal Trade Commission a letter encouraging the Commission to investigate manipulative marketing in children's apps. A new study found that children's games frequently disguise advertisements, coerce children into making in-app purchases, and characterize themselves as educational when they are in fact saturated with advertising. Chairman Simons, do you believe this business practice constitutes unfair and deceptive practices under Section 5 of the Federal Trade Commission Act?
Yeah, without reaching a conclusion on any specific issues, specific matters, non-public investigations or whatever, certainly that's a concern for us.
Yeah, and just a little more info here. In one game, the main character starts crying if the child playing does not spend money on the app. In another game, Barbie continuously urges players to put on clothing that can only be unlocked through an extra purchase. So these are, from my perspective, unfair and deceptive practices, taking advantage of kids, and we just have to do something about it. So thank you for that. And finally, just let me say that we do need new protections for young people. Any comprehensive privacy legislation that Congress considers next year must include special safeguards for children and teens, must update the Child Online Privacy Protection Act of 1998. And first and foremost, we need to extend special protections to 13, 14, and 15-year-olds who right now are not covered. We only went to under 13 in 1998. And so towards that goal, I will be reintroducing the Do Not Track Kids Act of 2019. So in addition to extending privacy protection to teens, the bill bans targeted advertisements to children, creates an eraser button for parents and children by requiring companies to permit users to eliminate personal information posted by the child, and prohibits the sale of connected devices targeted towards children and minors unless they meet the strongest possible cybersecurity standards. Commissioner Chopra, what do you think? Do we need to add protections in for these areas?
Well, I hope that as part of the whole comprehensive privacy bill debate, you look at updating that. There are places where we will have some ideas of where it needs to be updated and catch up. And let me just say that this is part of the reason why it was good Congress gave us rulemaking. Rulemaking allows us, with the parameters you set, to update the law based on what's happening in the marketplace rather than it just staying static.
Yeah. If we reach a consensus on nothing else, it should be on the children of our country, not just being a product that all these companies are trying to create for their own financial benefit. Thank you, Mr. Chairman.
Thank you, Senator Markey. Senator Udall.
Thank you very much, Mr. Chairman. And let me just say, I'm still on the Appropriations Committee, and I'm not going to abandon you if you want the FTC to have additional resources. And I'm happy to co-lead a letter with you or whatever to push for the additional resources. I think it's appalling that they're below the Reagan administration level in terms of employees, and I think we all know that they've made a very persuasive case on that here today. While the FTC should be conducting a significant amount of work to protect consumers, I'm very concerned about what the appointment of Matthew Whitaker as acting Attorney General says about the future of consumer protection, not only in the World Patent Marketing case, but other consumer protection enforcement actions. Before he was hired as Chief of Staff to Attorney General Jeff Sessions, Matthew Whitaker served as a paid advisory committee board member to World Patent Marketing, World Patent Marketing is under criminal investigation by the FBI for allegedly scamming millions of dollars from consumers. It paid a $25 million fine to settle the FTC investigation and to shut down the company. Mr. Whitaker is known to have sent at least one threatening email to a dissatisfied customer to defend his company. And most shockingly, media stories say he was issued a subpoena for documents but failed to comply with the subpoena. Reportedly, he was too busy moving to Washington, D.C. to go to work for the Justice Department. The FTC is tasked with a critical mission, consumer protection, and we must do all we can to protect your ability to continue to do so. Chairman Simons, my colleagues and I sent you a letter this morning regarding Mr. Whitaker's involvement with the World Patent Marketing case. It is worrisome if a person so closely involved in World Patent Marketing could fail to respond to a lawful subpoena, and that he is now appointed to be the nation's chief law enforcement officer, which many believe is unconstitutional and illegal. I will now ask you a series of yes or no questions. Did the FTC seek a subpoena for Mr. Whitaker in the World Patent Marketing case?
Senator, so this case was done before any of us showed up at the commission, and I don't have the details of what went on in the case. It was quite extensive, but I would be more than happy for the staff to come talk to you and brief you, and they have all the details.
Okay, we'd be happy to do that, and we would really like to have solid answers on these, and we'll get. If you don't have a copy of the letter, I hope you have it, but.
I haven't seen it yet, but I'll make sure I get it.
The House is also very interested in this. House Democratic members wrote you about this case, seeking information to be shared. Are you complying with that request?
We certainly are.
Okay, and you'll give us everything you're giving them?
We certainly will.
Okay, and you've agreed to brief us on the details. Additionally, if the Department of Justice attempts to interfere with the enforcement of the stipulated order against World Patent Marketing, will you notify both the majority and minority staff of this committee?
The only reservation I have is if my general counsel tells me for some reason I can't do it, but absent that, yes.
But thinking about it here, I mean, if that happened, interfering with you, you must be concerned about that.
Oh, I'd be extremely concerned.
Yeah, and so I'm not even sure you'd listen to your general counsel, would you?
Yeah,
that's okay. You don't need to answer
any
that.
kind of political intervention would be something I would be very, very allergic to.
Okay, good.
Senator, I just want to say I have no concern about any of my colleagues, including the chairman, engaging in any special treatment or being stooges to anybody. And you should have no concern that we are going to exercise our authority independently.
Good.
I also wanted to add that I think it's important. I think I can speak for all of my colleagues here when I say that from our perspective, compliance with FTC subpoenas and investigation demands are not optional, and we will pursue people who receive them to the fullest extent of the law to ensure compliance.
Thank you, Commissioner Slaughter. Mr. Chairman, are you aware of any previous instance when a potential party to an FTC order has served in a senior DOJ position? Can you think of anyone where you had that situation? We've been trying to research it. We can't find anything. So any of you can think of anybody? We've been promoted. The guy's now acting Attorney General of the United States of America. Okay, your blankness, I will take that as you can't think of any incidents. Is that fair?
That's
All
fair.
of you are nodding. Mr. Phillips, please.
I just want to add one thing. I agree with everything my colleagues have said, and you absolutely should rest assured that we will not let any kind of politics interfere with the work we do. What I will say, though, is that what I will also say is that the history of our work with the Justice Department has been a very positive thing. We've worked together as partners, and I'm certain I speak for all of us when I say we all expect that to continue.
And it has continued.
Yeah, and I know that very well. That's what concerns me.
Yeah,
I'm very aware of what you're saying.
We recently had a big case involving MoneyGram where they did a terrific job working alongside our staff, and we recovered $125 million.
Thank you all for your service. Really appreciate the work you do on behalf of consumers. Thank you, Mr. Chairman. Sorry for running over a little bit there, but I was kind of taking General Blumenthal's lead here. That's how I know him. You know, we're former attorneys general. He served 20 years. I only served 8, so I still call him general.
Part of your time was indicating a willingness to cooperate with me, so I wasn't counting it, Senator Udall. Thank you. Senator Hassan.
Well, thank you, Mr. Chair, and Ranking Member Blumenthal. Thank you for holding this hearing, and thank you to all of the commissioners. Thank you for your service and for your testimony and answers today. I want to start by following up on the topic of how we're doing on protecting our kids that Senator Markey started to raise. Earlier this year at the confirmation hearing for most of you, I discussed the possibility of the FTC examining the issue of children in the video game space. Specifically, we discussed loot boxes, which allow in-game purchases with real currency for surprise winnings, and most of you agreed that this is an area that could use additional oversight by the FTC. Loot boxes are now endemic in the video game industry and are present in everything from casual smartphone games to the newest high-budget video game releases. Loot boxes will represent a $50 billion industry by the year 2022, according to the latest research estimates. Children may be particularly susceptible to engaging with these in-game purchases, which are often considered integral components of video games. And just this month, Great Britain's Gambling Commission released a report finding that 30% of children have used loot boxes in video games. The report further found that this exposure may correlate with a rise in young problem gamblers in the United Kingdom. Belgium, the Netherlands, Japan, and other countries have all moved to regulate the use of loot boxes in video games, given this close link to gambling. So given the seriousness of this issue, I think it is in fact time for the FTC to investigate these mechanisms to ensure that children are being adequately protected and to educate parents about potential addiction or other negative impacts of these games. Would you commit to undertaking this project and keeping this committee informed about it?
Yes.
Yes.
Okay.
Yes.
I'm seeing nodding heads.
Yes.
Okay. Wonderful. Thank you. I also wanted to follow up on something that I know is of an interest to Commissioner Slaughter and Commissioner Wilson. You mentioned it too, so maybe I'll start with you, Commissioner Slaughter, and then we'll let anybody else who wants to respond. We've discussed that the heroin, fentanyl, and opioid crisis is our most pressing public health and safety challenge, facing both my home state of New Hampshire and the home states of just about everybody in the United States Senate. It's taking a massive toll on our communities, our workforce, our economy. So we all understand that this is an epidemic that impacts people from all walks of life in every corner of every state, and it really requires a concerted, all-hands-on-deck response and approach, including from agencies that may not traditionally be focused on some of the issues that the epidemic presents. It's my understanding that the investigations surrounding deceptive marketing practices with regard to products like opioids, and Commissioner Wilson, you mentioned recovery programs as well, but it's my understanding that right now these are handled through a 1971 Memorandum of Understanding between the FTC and the FDA. Is the protocol from 1971 working specifically for opioids, or should we revisit this to ensure that we're doing all we can to fight the epidemic? And I'll start with you, Commissioner Slaughter.
Thank you for the question, Senator. As a parent, as a person, the opioid epidemic literally keeps me up at night, and I agree with you that it is something that requires an all-hands-on-deck. Too many of these addictions start with legal prescriptions in the first place, and so I think one of the really important tools we need to apply is all collective efforts to keep people from getting addicted to begin with. And I think it is a great idea for the FTC, the FDA, DOJ to all sit down together and consider how we can best employ the statutory tools at all of our disposal to most effectively combat this epidemic where it starts.
Thank you. Commissioner Wilson, would you like to comment?
I agree with Commissioner Slaughter's comments. I would also like to note my understanding since I arrived is the FTC and the FDA have been working closely on ways to combat this problem together.
Right.
They have sent out letters to marketers of products that appear to have false claims. But I agree that if there are ways that we can work more closely together, we should be doing that.
Thank you. Anyone else want to comment?
I guess I'll just say that we now know years later that the maker of OxyContin knew that their drug was very addictive, being snorted, and they continued to advertise it as the less addictive pill. Now, if we don't figure out how to sanction companies like this, we will see this happen again in a different field. So we need to see all of this that is happening is downstream from that. We know that what happened, we did not get justice there. And so we have to be on alert and maybe be thinking broadly about how are we going to hold pharmaceutical companies accountable when they break the law repeatedly. You know, we grant them government patents for them to promote innovation, but when they consistently abuse it, we really need to think about what the sanctions should be.
Thank you all for that, and I look forward to working with you all on it. Thank you, and thank you, Mr. Chair.
Senator Cortez Masto.
Thank you, Mr. Chair and Ranking Member for holding this hearing, and welcome to all 5 of you. Let me just say I'm very supportive of and have been over the years of the FTC, for similar to my colleagues as an AG, worked closely with the FTC, and so appreciate your candor in coming forward and talking about the needs and the direction where you see we need to be focused for the future. I do support additional resources. I think you are understaffed for just the very reasons we talked about today. I know, as somebody who was former law enforcement, yes, you can always use more money, but it can be used so effectively to not only protect consumers and competition, but we've seen the positive impacts of it. So I support any direction that we move forward for your organization. Let me jump back, though, to the conversation that we have on privacy and data security. This is our future, and we need to get a handle on this. That's why this is a discussion that I so appreciate. Some of my colleagues are working on legislation. I'm looking at something as well. But one of the conversations we've had over many hearings is this idea of data minimization. As you're aware, we're talking about, this is the idea that businesses should only collect, process, and store the minimum amount of data that is necessary to carry out the purposes for which it is collected. But we also know that at the same time, we are in the age of big data analytics, which is going to be necessary as we move forward with smart communities, artificial intelligence, so many important technological future for the use of this technology. I'm curious in your thoughts on how we balance that. And let me put it to you this way. A lot of the questions on this have been asked on your thoughts on how we address data security and privacy. One of the things I heard, though, was the targeted rulemaking authority FTC should have. And I'm curious, and I know that was Commissioner Wilson, you talked about that. What do you mean by targeted? And if you could address it, are you including in that the idea that finding this balance between minimization as well as big data analytics, and how, by giving you that targeted authority, it allows you to kind of grow into this space and evolve and be flexible with it without Congress coming in and dictating this is where you can only go and this is where you cannot go. So I'm curious, just if you don't mind talking a little bit about targeted rulemaking authority.
Sure. So to take a step back, when you talk about the data minimization and artificial intelligence, these are topics that the FTC is exploring in the hearings that are being held. We have held a number of hearings on related topics. We will continue to explore these topics. We appreciate the input that we have been provided, and we are working through that input with the FTC staff. And so we will continue to think about and grapple with these issues. In terms of the rulemaking that I mentioned, Congress enacted COPPA, Gramm-Leach-Bliley, a number of other laws, and then delegated to the FTC after creating the broad strokes of the legislation, filling in the gaps, and creating some of the specifics to the rulemaking authority of the Federal Trade Commission. I do agree that that would be appropriate here. As my fellow Commissioner Phillips mentioned, we do believe it is appropriate for Congress to establish the balance between the different values that are being considered, but then to ask the FTC as the expert agency to help flesh out some of the specifics and then to maintain a rule going forward that can evolve as the market evolves.
Please, go ahead.
I want to add that I think some of the benefits of rulemaking that are important to consider are first flexibility. As technology evolves and practices evolve, we want rules to change and evolve and keep pace with them, and rules can change and evolve more easily and more quickly than statutes can often. And the second is the element of rulemaking that involves openness, transparency, and stakeholder involvement. Notice and comment rulemaking requires an opportunity for stakeholders, public advocates, good government groups to have an opportunity to consider the rules that we might propose, to issue comments, to have us reconsider them. And that back and forth is a really important part to make sure we're doing it right and make sure stakeholders are actively engaged. So I think those are benefits that are important to keep in mind as you consider crafting legislation.
Senator, on minimization, this is really in some ways not a new concept. In the Fair Credit Reporting Act, there's disposal. In COPPA, there's some minimization concepts. In GDPR and many of the other global privacy laws, data minimization is key. And I want to be responsive to your question. You can still harness some of the benefits without necessarily keeping a dossier on every individual consumer about individual data. Your search, if you run a search engine, your algorithm can get better and better without you keeping the search history of every single person who's used it. So I'm not sure the trade-offs are incredibly hard. They need to be thoughtful, but I think that balance and minimization, that's becoming the global norm. And because the U.S. has not really passed a comprehensive privacy law, the rest of the world is essentially already converging around that. So I expect that our firms are also going to be complying with that anyway.
Okay. Thank you. I notice my time is up. Thank you.
Senator Capito.
Thank you, Mr. Chairman. Thank all of you. Thank you for your service, and thank you for being with us today. I recently had a birthday, and my phone rang, and I looked down and I thought, oh, I'm sure this is a birthday greeting from one of my friends that I didn't have in my address book. And lo and behold, it was a robocall trying to sell me insurance. I cannot tell you how many times my constituents say to me, Congress has got to do something about this. I thought we addressed it, we've had hearings on it. And so I guess my question to you is, because I know there's some jurisdictional issues with FCC and FTC, so I'm going to throw it open to the panel. How can we stop this practice of spoofing numbers and locations onto your phone? And really for elderly people, which I represent a state that has a lot of elderly people, when you tell your grandmother, don't pick up the phone unless you know who it is, you could be doing her a good service or maybe not such a good service, because it could be somebody registering an emergency call or something to help her out. So would anybody like to tell me the status of this and who's really taking the lead here between the FCC and the FTC?
I think this is a joint effort. So they have authority and powers that we don't have, and maybe vice versa. So we work with them to try to, like for example, one of the things that they've done recently is empower the carriers to do some call blocking and identification, which is helpful. On our side, one of the things that we have done is run technology challenges that have produced some software which is now on the market, which you can load onto your smartphone and which will block robocalls. And one of them even will send the call to a bot, which will keep the robocaller online indefinitely, wasting their money and time and not yours. One other thing I would say is I think it would be a significant help to us in dealing with these robocalls if we got rid of the common carrier exemption, because a lot of the robocalls are coming through specific carriers, and these carriers know that they are transmitting robocalls.
So that would take legislative action then?
Yes.
To block that?
Right.
Well, again, I think it's frustrating and a challenge. We all get it. But for particular reasons, I think it can be damaging to individuals.
Mm-hmm. Oh, yeah.
I'm going to change to the topic of fraudulent addiction and recovery centers. I believe Commissioner Wilson mentioned it in her opening statement. Senator Cortez Masto and I were able to get that into the big bill. Based on stories of people either, I guess the term is body brokering, which I hadn't really heard, or convincing addicts to attend fraudulent rehab centers, not really having a quality index of rehab centers, and particularly for an area like mine and other areas that are deeply affected, this is of grave concern. So, Commissioner Wilson, could you speak to that a little bit? What direction the FTC is going on this?
So my understanding, of course, I've been there just a few short weeks, but my understanding is that staff is very focused on monitoring claims that are made and ensuring that claims that are made are valid and accurate, and to the extent they're not, staff is pursuing those claims. There are a number of non-public investigations that are ongoing right now, and I think we all agree with you that this is a significant issue. If people are addicted and are seeking to end that addiction, they need legitimate help as soon as they're ready to receive it. And wasting time and money with false or ineffective treatments is a travesty.
Or even treatments where you fraudulently bring them into your system for treatment, and all you're doing is giving them more drugs at the same time. And I know a couple of those cases that have come up. But I know, as friends of parents who have had this issue, you're going to do anything you can to help your child or your husband or your wife or whoever it is. And you're so vulnerable at this time, especially maybe it's not your first treatment, but it's your second or third, and numerous overdoses and everything. So this is an area of great concern. Did anybody else want to speak about that on the panel? Yeah, Commissioner Phillips, yeah.
I just wanted to thank you both for your efforts. You've given us new authority, and we mean to use it.
Okay, last question I have on fraudulent marketing would be I didn't realize this was a problem, but my staff brought it to my attention. The fraudulent Made in America label. How prevalent is this, and what are some of the means you're going to try to curb this practice?
This is fairly prevalent. We get hundreds of these, hundreds of complaints a year that people are improperly using the Made in the USA label. And we are committed to investigating those. And usually, a lot of times, what happens is the company doesn't even realize that it's a violation, and so we explain to them it's a violation, and they stop it. Sometimes companies do it intentionally. Sometimes we tell them, and they don't stop, and those people we sue. And one of the things that we're exploring now, as a general rule, we've only gotten injunctive relief in cases like this previously, but now we're exploring whether we can find a good case that would be appropriate for monetary relief, so to serve as an additional deterrent.
I just want to add here that I think there are manufacturers out there who hire American workers and who purposely do that because they want to put the flag on their product. And for those who lie, this cheapens the Made in USA label. So it's not just hurting American consumers, it's hurting every American manufacturer who is trying to do right. So, I want us to be much more aggressive with this, actually. And if you and Senator Cortez Masto want to team up again, finding civil penalties for some of these bad actors, we can really make sure we increase compliance levels. And I got to tell you, right now, there's country of origin labeling issues in agriculture, country of origin issues in product marketing. We have to do more to put a stop to this because this is extremely unfair to honest companies.
Yes. I agree with everything my colleagues have said, and I would add that Commissioner Chopra's point about financial penalty authority is a well-taken one. If in order for us to assess monetary we'd say penalties, but in order for us to get a monetary remedy right now, we'd have to show a monetary harm and show a price premium and make that demonstration. That can be very difficult to do. So we can't just say, you've broken the law, now pay the government money, even if the ability to do so might really deter some of this reprehensible behavior.
We would like to reduce these, or at least I would like to reduce these settlements that end in no money, no findings of fact, no nothing. We just received a comment letter from a company who actually was denied the ability to sell their products to members of the military because one of our respondents actually was violating this. So this is extremely unfair, and we need to fix it.
All right. Thank you. Thank you, Mr. Chairman.
Senator Blumenthal surprised me and indicated he has a couple more questions. Senator Blumenthal.
Thanks, Mr. Chairman. I know how grateful you are for my additional question. I want to again, by the way, in all seriousness, thank Senator Moran for his leadership here. We, believe it or not, we have an excellent team going, and I want to thank our staff who have prepared for this hearing. And come back to the Whitaker issue that was raised with you, Mr. Simons, Chairman Simons. There has been a report that Mr. Whitaker contacted one consumer to say that there would be, in quotes, serious civil and criminal consequences, end quote, if that consumer engaged in any further online negative reviews of world patenting marketing. Are you aware of that report?
I've seen that, yes, sir.
Are you aware of facts that would substantiate it?
I don't have the detail on that. As I mentioned to Senator Udall, this case was completed before we showed up.
Well, it was
FTC, and we would be happy, and we would be very happy to have the staff who has all the details provide a complete briefing for you.
Are you aware of facts that would substantiate that report?
Personally, no.
But your staff has such facts?
My staff has the facts.
Okay. You would agree with me, would you not, that that kind of statement
that's
would
troubling.
be improper?
That's troubling, yes.
And possibly illegal?
That's troubling.
Are you aware of a subpoena that was issued to Mr. Whitaker? I know that Senator Udall has asked you a similar question. I'm asking you whether you're aware of any subpoena that's been issued to Mr. Whitaker by the FTC.
Yeah, I haven't studied what subpoenas have been issued in that case, but like I said, the staff has all the details, and it's not a secret. They would be more than happy to provide a briefing.
Are you aware that the email Mr. Whitaker sent to that consumer was on the FTC's docket in that case?
I'm not aware personally of that.
Would you be aware of subpoenas that have not been complied with?
Potentially, but you know, I'm not aware of what happens with every subpoena that the commission issues. We issue lots of subpoenas.
This subpoena is a pretty high-profile one, correct?
Like I said, we weren't at the commission when this was voted out.
Would you agree with me that anyone, particularly somebody involved in the case as a potential defendant, has an obligation to comply with FTC subpoenas?
Yeah, we definitely expect people to comply with the subpoenas when we issue them.
So you're not taking...
There might be circumstances where they wouldn't. Like, so for example, if the subpoena went out and the case settled the next day, then you don't go out and try to enforce the subpoena because you've got what you need already and you've settled the case. But generally, if we need the information, we should enforce the subpoena.
But that kind of circumstance was not present here, was it?
I don't know. But like I said, the staff would be happy to brief you.
Well, I'm asking you these questions not only because they're significant to Mr. Whitaker, but they're important to compliance with your subpoenas. Yes. If the world thinks that they can claim, well, I'm moving from one house to another, or I'm moving from Washington, D.C. to Iowa, or Iowa to Washington, D.C., and that's enough reason to just say, forget about it, you'll have diminished compliance with your subpoenas, and that will take more resources to enforce them. So it's really in your interest to have answers to these questions.
Yes,
correct?
If I can jump in for 1 minute. As
Yes,
the
of course.
junior commissioner on the commission, it is my responsibility to work with the general counsel's office to respond to motions to quash or motions to limit subpoenas and CIDs. I can tell you we take this very seriously. There has been an instance recently where I worked with the general counsel's office to say, no, we are not going to quash the CID, and we fully expect that the respondents will not comply, and we will take them to court to make sure we get the information that we need from them. I've actually told my staff I'd like to sit in the investigational hearing when those people are brought in to give testimony, because I'd like to see who it is that wants to flout the authority of the Federal Trade Commission. So we do take this very seriously.
I'm sure you do. Well, let me ask you, Mrs. Wilson, do you have knowledge of this subpoena to Mr. Whitaker?
I have no knowledge of these circumstances, no,
Why not?
because I was sworn in 2 months ago.
Well, you had to know we were going to ask you about it today, right?
The chairman's office has been dealing with this issue, it's my understanding, and I have not been briefed on this topic.
Well, I really think that you owe this committee answers quickly about this subpoena for the sake of your law enforcement credibility.
So we're happy to provide the details. The staff can give a briefing, they can be full and open, and it's not an issue. We're happy to do it.
And when you're going to be full and open, I assume there's no problem with our disclosing the circumstances, because the case has been settled, correct?
Correct.
Okay. And it, by the way, $26 million settlement, that's not a nickel and dime small-time case.
That's a
big deal.
serious case for us, absolutely.
Right. Has anyone from the White House ever communicated with you about this case?
Not with me.
With anyone in the FTC, whether it's the staff or any of present or past commissioners?
Certainly not that I'm aware of.
Any other commissioners aware of any contact from anyone in the White House, from the president on down, about this case? And the records show that everyone is shaking their heads no. And are you aware of the White House contacting anyone at the FTC about Mr. Whitaker, if not about this case?
No.
And the same is true of others?
No.
Has the White House contacted you, Mr. Chairman, or other commissioners about hiring anyone for either the FTC staff or in any other capacity?
I don't remember anything like that.
No one has asked you to hire anyone either from the private sector or from another government agency?
I don't remember anything. I mean, I have very little contact with the White House.
What kind of contact do you have?
I've had lunch at the White House mess where I was introduced to the nominee for the BCFP and the general counsel of the Commerce Department, because our agencies, work together, and that's really about it.
And the purpose of that lunch was to introduce you to those individuals?
Yes.
Okay. And I'm assuming that you will let this committee know of any contacts between you or any of the commissioners and the White House staff, meaning any of the political appointments, including the president.
You mean in conjunction with Mr. Whitaker?
Or in any other way? Can we have that commitment from you?
I think I would like to talk to the general counsel just to make sure there's not a reason that I can't do it.
I'm happy to give you that opportunity. Thank you. That concludes my questions, Mr. Chairman. Thank you.
Senator Blumenthal, thank you very much. As you indicated, I appreciate the opportunity to work with you. Let me ask a couple of questions, and then I think we can conclude this hearing. There has been concerns raised about the recently adopted California Consumer Privacy Act. Those concerns, that act is expected to take effect in 2020. The concerns are that legislation will influence other states to enact their own versions of privacy regulations, each of which would potentially impose differing obligations on companies and different types of protections and remedies for consumers. As the federal agency that has primary expertise over unfair and deceptive practices affecting interstate commerce, what are your thoughts about this state-by-state approach to regulating privacy practices of U.S. companies, and whether that complicates the consumer's ability to enjoy the same privacy protections no matter where they live or use the internet? Do you believe that there is a potential for consumer confusion between federal standards and varying state-by-state approaches?
I'll take that. Sure, I think that is a possibility. If you've got a good federal statute, and you've got state statutes that are either inconsistent or varied, I think you can get confusion. And depending on the right, what the mix is and the details, federal preemption might be the way to go on that.
Mr. Phillips.
Thank you, Senator. One of the things that I've said publicly, including here today, about federal privacy legislation is that we should keep competition in mind. For large businesses, it's easy to deal with lots of different compliance costs. For smaller businesses, having one clear rule can help them compete.
Can I just add that of all the preemption that occurs, you should tread very, very carefully. We saw how preemption of state law in the mortgage market, and the same argument was used about making sure that there's enough entry, not confusion. That preemption of state laws there was catastrophic. And there are certain states that may want to have higher standards than the federal law. We can talk about material conflicts, but broad preemption, I think, would be a huge mistake. But I'm happy to keep talking about that with you and figure out how we can balance all the things you're concerned about.
I would say that I'm not concerned about states that want to have strong laws. I am concerned about the idea of inconsistent laws between states. So I think there could be a case for federal preemption as long as a federal law was really meaningful and really strong. I would be very concerned about a weak federal law that replaced strong state laws.
So I do respect federalism and states as laboratories for democracy. In the words of Justice Brandeis, the states provide an important opportunity to conduct novel social and economic experiments. And so I would be wary of advocating for preemption in very many circumstances. But I think in this kind of circumstance, it will be important to do that, I think, for the reasons that you described for consumer confusion, but also businesses need clarity and predictability so that we don't dampen innovation and chill competition. As Commissioner Phillips noted, if there are small companies trying to get into the marketplace and they're looking at a patchwork of laws, it raises the costs for them to enter. And so I think in this kind of circumstance, preemption would be useful for consumers and useful for competition itself.
I have great regard for everyone's commentary on this topic. It's a challenge. Ms. Slaughter, you did say something that catches my attention in that this may be the way to find the solution to this issue is by the strength of the federal law. In other words, there's a give and take that takes place here. Something that we can further explore as we try to figure out a solution to federal legislation. I support privacy rules that afford consumers the same protection no matter where they are in the internet ecosystem, slightly a different topic than the one that we just were talking about. Would you agree that regulating and enforcing privacy rules based on the sensitivity of the data collected, used, or transferred, or stored is a preferred approach and in the best interest of consumers in terms of certainty and transparency? In other words, the standard, the focus should be on the type of data that's involved and its consequences of being impaired from privacy protection. Makes sense? Senator, I called you Senator twice. I've disparaged you promoted on 2 occasions. I'm sorry. Commissioner Phillips.
In my heart, Senator, I'm still a staffer. What I would say is this. The system we have today in America, the system we've had for a long time, protects health information especially. It protects information about children. It protects financial information. And that reflects a collective judgment that there are certain kinds of data that the disclosure of which inappropriately may pose greater risks and may require greater care. Additionally, something we talk a lot about in the privacy world is that the idea of context, what consumer expectations are in a given circumstance, and that it may be reasonable for a consumer to expect more sensitive data to be treated with more care. So I definitely think there is a wisdom to how things have long been done. There's a collective wisdom reflected in our laws today. So I think that's definitely an important issue to keep in mind.
Thank you. Let me turn to a different topic. The FTC began holding open hearings in September to evaluating evolving technologies and business practices in an increasingly globalized economy, while also identifying possible changes to competition and consumer protection laws and enforcement priorities. Other topics, including data security and privacy, are scheduled to occur in the near future, as I understand, in early 2019. What would you describe as a high-level takeaway or priority action item that you've identified through this public process to date?
So
what have you learned so far, Mr. Chairman?
Yeah. So I think what we've learned so far is a lot of we've gotten views from both sides of the spectrum across a whole range, and so we're getting terrific input. We've had 200 people testify already from diverse backgrounds, and we've had a large number of written comments, some of them very detailed and very thoughtful. So we're getting a lot of input. I think at this point, we still have more to go, and in particular, we're going to get comments at the end of the process. So I think as of this point, we are still absorbing the input and synthesizing it, and we don't really have any takeaways in terms of what a specific output of the hearings is going to be.
Senator, one initial takeaway I have is that data is a more and more valuable asset every day to firms that are in our economy. The traditional ways we have looked at how to enforce some of our laws, whether it be on the antitrust side or the consumer protection side, we are trying to develop further views on that because there's clearly a race to get all of our data and figure out how to monetize it in a big way. This raises some issues that we deal with. It raises national security issues, but we are in learning mode. But certainly, we have to accept that we are going to do our job in a very data-oriented economy where that is similar to gold.
Thank you for that comment. I'm going to just soon turn. I have one question, then I'm going to turn to Senator Cruz. This one for Commissioner Slaughter. As you are well aware, we were successful in enacting better online ticket sales, the BOTS Act, in 2016. We provided the FTC and state attorney general's authority to treat any, quote, circumvention of a security measure, access control system, or other technological measures, including online bots, to suppress ticket purchasing limits as an unfair or deceptive practice. I understand there's an upcoming workshop on this topic, and I was interested if you would explain this to me, but more broadly than that, how are we coming along on the enforcement of the BOTS Act?
Thank you for the question, Senator. This is one of those issues like robocalls that people really care about. Consumers really, really care about it, and it really makes them nuts when they cannot get tickets to their favorite show or a play. And that's an important thing for us to take seriously. So it was my pleasure and privilege and honor as a Senate staffer to work with your office on the legislation, and now it is my pleasure and privilege and honor to be in the position of considering the enforcement of it. So I would say two things to you. First, in terms of enforcement, we're actively monitoring for enforcement opportunities. It's an important tool that we've been given, and we need to use it, and we would like to use it. And then in terms of the workshop, our goal, I think, is to gather stakeholders, get input to make sure we're staying abreast of the technological developments in the ticket industry. It is a very fast-moving target, And so we want to make sure we know what's going on, we're targeting our investigations and enforcement efforts appropriately, and that we're appropriately communicating with you to make sure that we continue to have the tools we need to try to tackle this important problem.
Do you have any colleagues as commissioners who don't share your enthusiasm for the BOTS Act that I need to question?
I cannot imagine that any of my colleagues don't share my enthusiasm.
Maybe I should ask them. Are there any commissioners who do not share the enthusiasm for the BOTS Act? I see.
That was a double negative, but we share her enthusiasm.
Thank you. Senator Cruz.
Thank you, Mr. Chairman. Welcome, everyone, and would ask you to convey my well wishes to all the wonderful people that work at the FTC.
Be happy to do that.
It's good to see you. I want to raise a topic that we've discussed at some length in the past, which is big tech. And there are many issues about big tech that intersect with the FTC's mission and mandate. So I want to start with this past spring, the Commission received several requests to investigate Google's alleged violations of privacy. One request from Senators Blumenthal and Markey detailed what they described as Google's deceptive and intrusive collection of location information on Android smartphones. Another request came from the Electronic Privacy Information Center, raising concerns about Google's tracking of in-store purchases. Yet another was filed by 7 consumer groups about Google's deceptive by design user privacy settings. And the list goes on. And I wanted to ask Chairman Simons, has the Commission investigated the claims in those letters, and what have you all found?
So I can't talk about any specific non-public investigation, as you know. But one thing I will say is that if you read about it in the press, if there's a congressional letter that points out a potential problem, we're on it.
Good.
We look at those things very carefully.
I am glad to hear that. Let me ask a broader question to each of the commissioners. During the February nomination hearing, which most of you all participated in, I highlighted concerns that was raised in an article published in Esquire that detailed how, quote, Facebook and Google are together worth $1.3 trillion, which, to put that in perspective, you could merge the world's top 5 advertising agencies with 5 major media companies and still need to add 5 major communications companies. And by the way, that would be WPP, Omnicom, Publicis, IPG, Dentsu, Disney, Time Warner, 21st Century Fox, CBS, Viacom, AT&T, Verizon, Comcast, Charter, and Dish, all merged into one giant company, and that would still only total 90% of what Google and Facebook are together worth. Does the Commission have concerns about that massive accumulation of power that big tech has? And in particular, how should antitrust law approach that massive concentration of power?
Thank you, Senator. So in the antitrust context, we're worried about exercise of market power, right? And so that's where you want to look for the anti-competitive conduct. That's where you want to look for your case generation and for your investigations. And so, of course, when you've got a situation, but let me say this also, which is that the fact that they're big doesn't mean it's a problem under the antitrust laws. Big is not necessarily bad, but if you got big by being bad, if you got big through anti-competitive conduct, or you're staying big because of anti-competitive conduct, that's something that we need to prohibit and we need to stop.
Any other commissioners have thoughts on that?
Senator, I'll just add that if you talk to investors, many of them will tell you that they're not going to fund a new startup unless they can figure out how to sell that company to an existing large incumbent like Google and Facebook. And that makes me question, do we have a really competitive, innovative economy where investors are putting money only into ideas that they can sell to an existing incumbent? We should want to live in an economy where people are investing to create new ideas that challenge and that create real rivalry. And I worry about, writ large, when companies are trying to get going, but a larger incumbent can seal their fate by cutting them off. So, you know, we take these issues seriously on the privacy side and the antitrust side, but it is clear that we have to think about this hard, and so do you.
I think you raise good and important concerns there. Let me shift the discussion slightly to a different aspect of big tech's power, which is, as I'm home in Texas and listening to Texans, a concern that I hear on virtually a daily basis. Is that the major technology companies are far too willing to engage in censorship, that are using their market power to silence voices in the political market space, in the public discourse with which they disagree. In recent weeks, media outlets have reported that Facebook fired a senior executive because of his political views, that we've also seen Twitter recently getting bolder and bolder, blocking conservatives altogether from speaking and just banning them from the platform because what they were saying was inconsistent with Twitter's political views. And one of the frustrating things from the perspective of this committee is there is virtually no transparency. There are no objective data. Twitter, Facebook, Google, they don't answer any questions. They don't answer the extent to which they are silencing people, the extent to which political bias is affecting those decisions. How can and should the FTC address that concern that is being raised, and it is a concern of millions across the country?
It's not clear to me that the FTC should be addressing that at all. This was, what you're describing is something similar to what the FCC used to do with the Fairness Act. And so maybe there's an FCC angle there that is appropriate for either the Congress to pursue or maybe the FCC to pursue. But unless it's something that relates to a competition issue or it's unfair or deceptive, then I don't think we have a role.
I'll just add here that I think the public, you're right, knows very little about how some of these companies make decisions. And there are free speech issues which may not be in our, authority. But certainly, and as you know, Senator Cruz, the FTC has its 6B authority, where we can compel certain information about business practices and based on a vote of the commission, make some of that information public. I think the FTC is well situated to do quite a bit of study and reveal some of those findings about how some of these companies operate, but I will think hard about what you're mentioning about speech as well.
And I would very much encourage you to do so. And I would also encourage the Commission, when you say that you don't think you have the authority to address these issues, you do have extensive consumer protection authority, and when tech companies are holding themselves out to the public and customers as neutral public forums and are actively engaged in hidden censorship, that is actively deceptive, and the FTC has a great deal of authority to address deception and to help provide transparency. And right now, big tech has been very comfortable refusing to answer these questions. The FTC, I think, has ample authority to help provide that transparency, which is, I think, something both the public and Congress would be very interested in knowing the answers to.
Senator, if I could just add one thing, just to echo something the chairman said before. We're very mindful of the very important antitrust and consumer protection authorities that we wield. I think part of the concern is those are not authorities to police the First Amendment itself. And you've been such a leader in defending the First Amendment. We want to make sure that we do the job assigned to us very carefully, but that we not tread into First Amendment implicating space.
Senator Blumenthal.
Yeah, I just want to make sure we understand each other. Senator Cruz was asking questions about antitrust authority, and as you'll recall, I made similar reference earlier in this hearing, and one of you indicated that your authority is limited to deceptive and misleading practice. The fact is, you do have antitrust authority, correct?
Correct.
Oh, very much.
Right. And the misuse of market power or market share, which is implied possibly, underscore possibly, by some of what we've seen lately, certainly would be within your jurisdiction, correct?
Yes.
I notice Mr.
Yes.
Phillips is nodding
Yes.
his head in assent, and others are as well. I think, you know, that we're expecting you to use the full range of your authority, consumer protection, antitrust, and they're both really deceptive and misleading practices that affect consumers, and antitrust affects consumers. In fact, the misuse of market power may include deceptive and misleading practices. So what I'd like to ask is a commitment from you that you will assess the market share of the big tech companies, the top 5, and that you will report back to us on what that market share is.
Well, I think our hearings and any studies we might do to compel information, you know, market share is a little bit of a tricky issue with this one. But let me just say, we have the antitrust laws, we have the FTC Act, we have other statutes Congress has given us, but several of the largest tech companies on the planet are also under order by the FTC. Google, Facebook, Twitter, and there's more. And we expect that those orders are followed. They are not suggestions, and so we also have that tool as well.
Well, this is a big question, and I'm not going to prolong this hearing, but I would like to follow up on it with some questions for the record on information that you could provide us that would reflect on the current potential antitrust issues that we've raised here. Thank you.
Thank you all very much. I would indicate, no further question from me, but I would indicate that you've caught my attention on the U.S. Safe Web reauthorization. And if you'd have your staff visit with my staff, we'd be interested in working with you about its reauthorization. And I've always had the practice of allowing witnesses before our subcommittee to add anything to the record they'd like to add. Is there anyone who has spoken today that would like to say anything further, something you left out, something you want to clear up, or something that you feel like we did not ask you? All heads are shaking to the negative, suggesting that you too are ready for this hearing to come to a conclusion. The hearing record will remain open for 2 weeks. During this time, senators are asked to submit any questions for the record. Upon receipt, the witnesses are requested to submit their written answers to the committee. I again thank you for appearing today and appreciate your cooperation. I was impressed by the nature of your responses, your testimony, your articulation of complicated matters, and I was particularly pleased to see the nature of the relationship that appears to be among all of you in working together. That is appealing to me. With that, this hearing is now adjourned.
Thank you.
I had no idea.
Something like civil fines authority, is that something that you personally think is needed?
I haven't reached a conclusion on, I need to see the totality of what the agreement would be, but I began the process with no initial opposition to civil penalties. So it is how it all fits into a larger package, but as an individual item, it isn't anything that I would take up.
For that legislation. And one of my takeaways from this hearing is, and I said this at the end, and it wasn't just perfunctory, as we develop this legislation, and this was said in the hearing, legislation is irrelevant, is unimportant if it's not enforced. The question of who enforces something is not just a throwaway issue. And one of the things I wanted from this hearing is to gain either a belief or a disbelief that the FTC was a place to put more authority when it comes to privacy. And I was pleased with the quality of the conversation that occurred today, the nature of the kind of the qualifications and nature of the people who serve in the FTC. And a takeaway for me is that there is a level of comfort after this hearing that on expertise and collaboration between FTC commissioners of working together, I feel more comfortable about increasing their authority in this space.
Including with civil fines or rulemaking, APA rulemaking?
Yes, ma'am.
You know, I've spent most of my life in law enforcement. And the best laws in the world, if unenforced, are dead letter. And law enforcement requires resolve and resources. Both are necessary. I agree with Senator Moran that this agency seems a lot more functionally effective than some of the other agencies that we had before us, a lot more collaborative. And the issue of privacy evokes on our side a lot more collaboration, at least it has so far. And we're going to differ on some of these issues because, you know, take preemption, not easy. But I think there is a consensus to be had.
Senator, would you support any bill that dilutes in any way the California privacy law?
Well, I see no reason that the federal standard should be any less protective of privacy than the California law.
What are you guys looking at in terms of timing? You mentioned in your opening statement that there's been a lot of progress made. How soon can we expect some sort of text?
All I would say is we're not going to pass this measure this session.
No.
But I hope, I'm speaking only for myself, my hope is we can have something to introduce early in the new session.
Is the likely incoming chairman, Senator Wicker, is he involved in this process as well? Is there?
He is.
He is, okay.
Yeah. Yep.
And Senator Moran, is there anything that in the bill that you would, that you think either must be included or must not be included in that total package that you mentioned?
There's no value at this moment for me to say and to answer your question. In the goal of getting something done, it is not useful to take anything off the table or to put anything as a prerequisite for continued dialogue. I mean, I suppose in a broad sense, what's on the table is something that ultimately increases the safety and security of Americans, protects them as consumers. And so how we do that has a variety of ways that it can be accomplished. And kind of one of the difficulties we've had is this issue of preemption. And your question about California or is what's transpiring in a global economy with what happened with legislation in the European community. We had a good hearing with the presence of representatives from California and Europe on this topic. But one of the things that seems to me in listening to my colleagues as we negotiate, and was mentioned here by one of the FTC commissioners, is the level of strength, the magnitude of the protection is perhaps an ability, if it's high, it's an opportunity for us to reach a conclusion about how to handle preemption. When Senator Blumenthal, and I'm not attempting to put words in his mouth, but when he says that he wouldn't expect anything to be less than California, that is a way that we can at least have negotiations about a national standard. That's an issue, but also what is the national standard is an even more important issue. So there's an opportunity for us to figure out how to cooperate on this issue, and I don't think it's a particularly partisan issue. I don't think it's a Republican-Democrat issue about preemption. I would tell you that in all my life as a Republican, I had the belief that local government closest to home is better than government far away, and I still believe that. You have better ability to influence the outcome, but with the magnitude of the problem, the size of the parties who play in this arena, and the fact that consumers live across 50 states, and now this is global, there is a requirement, there is a need for something that is national, so there is a standard that every consumer can rely on, and every perpetrator against our privacy can suffer a consequence.
Why not just copy and paste the California law if you need a national standard that won't dilute the California standard?
I've never. Senator Blumenthal said that. I've never reached a conclusion as what
we're
that
having
standard ought to be.
negotiations. I think that that we need to continue talking and negotiating in good faith without drawing arbitrary lines.
Senator,
What he said is what I tried to say earlier. He said it in shorter words.
there's a lot of talk and here about big tech, and Google and Facebook obviously have come under a lot of scrutiny, but you mentioned Equifax. How are you thinking about categorizing what this law might apply to, entities that this law might apply to?
I think the answer to that is, it is, I think that big tech is so pervasive that the focus has been on big tech, but it doesn't take big tech to operate it doesn't take big tech to violate people's privacy. So this needs to be encompassing. It ought to not be targeted at a company. It needs to be targeted at a behavior or at what is inappropriate. I indicated in my questioning of the FTC what kind of information that is intruded on is perhaps more important to me than the size or scope, certainly, of the company that's perpetrating it. So we ought to focus on the things that Americans hold dearest to them as the most private, as compared to singling out an invasion by privacy by a particular kind of entity. That makes sense?
Protection of privacy should be an obligation, no matter how big the company is.
But can't the big companies flout the privacy laws more easily, as the UK, as Facebook has shown in the UK, appealing their recent GDPR fine?
I think that's true, and the point was made today that big tech companies are hard to penetrate, to know, to be transparent. We don't have the understanding that we need as to what goes on at big tech. And the question that you ask raises this other point: is how do we make certain that we address the privacy issues that a big company creates without doing damage to somebody who wants to start a company, somebody who cannot afford to comply with rules and regulations, hire accountants, lawyers, and continue to have an economy that innovates. So, I mean, none of this is easy, and Senator Blumenthal's hope that we have a bill early in the next year is a hope that we all would have. But none of this is easy, or it would have been done earlier. And your question of why wouldn't we just, take something that somebody else has done? We want to. My goal is not to necessarily replicate something that's already out there, but to figure out what the best answer it is, and for us to get the necessary votes to pass something. I'm a supporter of 60-vote rule in the United States Senate. It means that we have to work together. It generally means that we're going to get a better product when we do. So. There is no one magic piece of legislation that is the thing that we can replicate, either because it wouldn't necessarily be the best policy, but it also has to be something that has the ability to garner 60-plus votes.
My hope is early in the session.
Senator Blumenthal, why did you request the market data on technology companies, and how do you hope to use it?
I'd be interested in market data they have as to the market share and power of companies in the big tech sector, and how that may reflect on the kind of scrutiny we should bring to bear.
But I mean, what sorts of policies could, you potentially derive from something like that? I mean, are you looking sort of at maybe finding the evidence to break up some of these big tech companies? What's the end goal?
Well, we don't, we don't have the power to break up companies.
Right, but you could urge the antitrust enforcement to do it.
We could urge, if the data is there and if there is abuse of power that would justify it.
Senators, one more thing on rulemaking authority. The FTC is sort of traditionally seen as sort of a risk-averse agency. I've had people tell me that there's some concern that if you guys gave them rulemaking authority, they might not really use it very much. Are you guys concerned about that, and how would you prevent that?
Well, one of the recurring themes, at least from me and others here is the importance of using the power and using it vigorously and aggressively. If they have the authority to make rules, they ought to use it. If they fail to use it, they ought to be sued.
Is there a way to put that into the legislation?
The FTC heard from many members of this committee today about the importance of utilizing their powers, so they were encouraged. The FTC commissioners indicated their desire to do so, their willingness, understood the importance of enforcement. This is a new FTC. I mean, I don't know what the rumors are about past FTCs or kind of the feel of risk adverse, but we have 5 new commissioners who can demonstrate their ability to do their jobs well. Hope they.
Yeah. I've got to run.
Senator Moran, I just had a quick question. I mean, you had mentioned the point is not to replicate something that's already out there, but
thank you.
Thanks, Richard.
Thanks, Senator.
Thank you. Just wondering if there's any specific provisions either in the California legislation or GDPR that you take issue with that you wouldn't incorporate into a bill. It just seems kind of weird to, reinvent the wheel. I understand you don't want to make the same thing, but.
I mean, what I would say is that we've had one hearing in which the California bill was defended by folks in California and attacked by others. I don't think we're in a position yet to make a determination about the pros and cons of specific provisions within that California bill. So it just work yet to be done.
Thank you guys very much. We also have to run. And if you have anything to follow up, let me know. Thank you.
Good meeting you.